Hello doctors, I'm Dr. Chris Rapoff of EZ QME Continuing Education, and welcome to this week's Case Law Update. Today's case touches on something that we as QMEs are confronted with virtually every time we interview an applicant prior to our examination, which would be applicant credibility. How do we assess one's questionable credibility and convey this to the parties without appearing to have any bias against the examinee? Well, the QME in this case does just that. So let's take a look and see how the doctor addressed his concerns and find out if he was persuasive enough for the appeals judge to consider a prior workers' compensation judge's decision on this case. Let's get started. Now, a few facts here before we get into the case itself. Mr. Hernandez, the applicant, is seeking reconsiderations of findings of fact and order that was issued by a workers' compensation law judge. And this judge found that Mr. Hernandez did not sustain an injury, AOE-COE injury, to his respiratory system, lungs, sinuses, and loss of smell. And the judge ordered that Mr. Hernandez take nothing by the way of his injury claim. Now, Mr. Hernandez contends that the trial record contains substantial evidence, including reports from a QME, that he did sustain an AOE-COE injury as he's claimed. To add some background for you, Mr. Hernandez is claiming a CT injury while he was employed by the defendant, in this case, Airfoil Technologies. The CT injury spanned from 1992 to 2007. So an internal medicine pulmonary disease QME evaluated Mr. Hernandez, and he examined him, took his history, and reviewed the medical records. Now, in this pulmonary disease QME's discussion, he states the following. The patient was not a particularly good historian. In addition, I'm missing medical records. He told me, Mr. Hernandez, that he had been seeing a doctor, but I would like to see all of these records. He states that he now sees another doctor, and I would like to see those records as well. He also states that he was diagnosed with asthma in 1995, but the records show asthma to have developed maybe a decade later. So the QME also continues and stated that there are other discrepancies in the terms of his work history. So Mr. Hernandez told the QME that he was a machine operator for Airfoil, but then only worked in the packing department at Praxair, another job. In documents that describe him as a painter for Praxair, and he was exposed to chemicals at that time. For Airfoil, Mr. Hernandez may have only worked with sawdust. So there must be some objective documentation of his job duties for both of these employers. In addition, there must be a material safety data sheet. This information will be necessary for me to review. He also states that the patient has asthma and a chronic sinus problem. To fully understand his asthma, I need to understand his sinus problems. I need to see the operative report and pathology reports of prior testing and procedures. And finally, the QME stated that he has stated in his original report that the patient was not a particularly good historian. The history and the medical legal reports, both of the QME and the treating physicians, may be inaccurate. This is why I prefer to review the contemporaneous medical records, if at all possible, myself. So as we see here, he's found a number of discrepancies in these medical records, and he needs to address them before he can give an accurate description and a discussion, including opinions and conclusions for this case. And this QME even goes further and describes a number of examples of discrepancies in the records. For instance, the history provided by one of his doctors recorded in one of the reports is that he denied any respiratory, sinus, or allergy problems before working for Praxair. He said that's not medically correct. He also reported that the records of another doctor clearly documented multiple visits between the year 2000 and 2007 for bronchial asthma or bronchitis. But in fact, he was seen as early as in 1994 for sinusitis. Another example is incorrect information recorded in the reports of another physician, whose report stated that the applicant, Mr. Hernandez, supposedly, quote, categorically stated that he had no problems prior to the employment by Praxair. Mr. Hernandez was asked if he ever had a claim against Airfoil for a pulmonary condition or any problems while he was working at Airfoil, and he said he never had those problems. Again, the medical records told a different story. So given the discrepancies that he summarized, it would be useful, in his opinion, to the QME's opinion, to obtain the records from the allergist, and he requested that they obtain those records. So given the discrepancies, he wanted to reevaluate Mr. Hernandez to try to better understand his work at each employer. And then finally, the QME stated that he did understand that he has been asked to see him regarding employment at Airfoil, and that Airfoil sold its business to Praxair. So if the parties agreed, he was going to schedule a reevaluation for the gentleman. So here you see we have a CT injury with two separate employers. However, it's the same business. So now we're looking to see if they're going to who's going to take responsibility for these injuries over that period of 15 years that he's claiming in a CT injury. Now, based on the information from the QME and the workers' compensation judge's initial ruling, the appeals board responds, and they indicated that an award, an order, or a decision of the appeals board must be supported by substantial evidence. Well, we all know that. A medical opinion, they state, is not substantial evidence if it's based on facts that are no longer germane, or inadequate medical histories, or examinations, or incorrect legal theories, or unsurmised speculation, conjecture, or guess. And to the substantial evidence, the medical opinion must set forth a reasoning behind the physician's opinion, not merely his or her conclusions. So a mere legal conclusion does not furnish a basis for a finding. That basically is our definition of substantial medical evidence. The appeals board ruling, they continue, and they say the QME, the pulmonary QME, repeatedly said that the applicant, Mr. Hernandez, was not a good historian, and that various medical records were inconsistent and conflicted with the work and the treatment history he was given by the applicant. So the QME concluded that he needed to review additional medical records and that he needed to reevaluate the applicant. So the appeals board says that their review of the trial record indicates that the QME was not provided the additional medical records that he requested, nor was he given the opportunity to reevaluate Mr. Hernandez. Thus, his reports were not substantial medical evidence on the issue of AOE-COE. So it wasn't the QME's fault. However, it still did not qualify as substantial medical evidence, his report. So based on those revelations that the appeals board had determined, they noted that in the report, the workers' compensation judge indicated that he didn't find the applicant to be credible, and actually stated that, quote, developing the record would not assist in rehabilitating the applicant's lack of credible testimony. So they're going to discount the testimony of the applicant. But then the judge goes on and says, however, the QME clearly requested additional records, including accurate assessments of Mr. Hernandez's work with Airfoil Technologies and Praxair. So they're trying to make a decision and divide out what type of work and what type of injuries could have been assumed by each of the employers. He also indicated that the additional records, as well as the reevaluation of the applicant, would help him address the discrepancies in the information that he was provided by Mr. Hernandez. So under those circumstances in the matter, upon its return to the work comp judge, they recommend that the parties provide the QME the treatment records and the employment information that he requested, and to schedule a reevaluation appointment. They also finally concluded that the QME should be informed that the purpose of the reevaluation is to enable him to clarify the underlying medical and employment issues necessary for the workers' comp judge to make a final determination regarding the issue that was submitted for the decision. So their recommendation was granting. They granted a reconsideration, rescinded the findings in order, and returned the matter back to the workers' compensation judge for further proceedings that were consistent with this opinion. So in this case, it goes back to the work comp judge after the QME has had an opportunity to reevaluate the applicant and see if he could ascertain what in the world was going on in this case. So in this case of Hernandez versus Airfoil Technologies, we're reminded that, again, qualifying a report as substantial medical evidence is of the utmost importance in any subject involving a PQME examination, even an applicant credibility. Providing the reasons and the conclusions in your report by scouring medical records for evidence or lack thereof is another example of providing the how and the why as we base our final conclusions in our decision and discussions. I'm Dr. Chris Rapoff and wanted to thank you for taking the time to join me again in this presentation. I hope you have enjoyed it. I look forward to sharing another interesting case again with you very soon. Thank you.